integrity. This is Worthy TV, truth and integrity.
And in June 1988 till April 1991, I was between 1991 and November 1996, I became a High Court registrar. Between 1996 and 1997, I was the Regional Administrative Officer of Judicial Service, 2nd. Then in September 1997, to December the same year, I was promoted to the position of Deputy Chief Registrar and was drifted to...
My Lord, your CV is very rich, so it's okay.
Thank you so much.
It's okay.
Yes, so whilst at the 2nd High Court, it's okay.
My Lord, that's why we want to go straight into the vetting.
Okay.
But some are saying you should give a brief background. Now, at a point, the members are okay with your brief background.
Thank you.
So we then proceed to ask you questions. So, Chairman of Judicial Committee, you have the floor.
Thank you very much. Justice Bright Mensah, congratulations on your appointment as the Justice of the Supreme Court.
Thank you.
My question is, what in your view do you consider as a threat to the judiciary in Ghana today?
Threat?
Yes. Yeah.
Threat?
Threat. Dangers.
THREAT. Threat.
Yes. It's a threat to the judiciary.
Danger.
Something that may pose danger.
Yeah.
To the
I'm not sure there's a threat to the judiciary.
Very well. Thank you. A question?
Yes. Question is, does the Judicial Council under Article 153 have sufficient power in protecting judicial independence, or do you recommend specific constitutional amendment? Thank you.
Mr. Chair, when we talk about judicial independence, the Constitution itself says in Article
125.
1251, and with your permission, I want to quote. It says, "Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, who shall be independent and subject only to this Constitution." Now, when we talk about judicial independence, we are talking about the work of the judges, and not the judges alone, but also the administrative setup of the judiciary. In the case of work done by the judges, which were called judicial activity, the Constitution is very clear on it that as a judge, if I'm sitting, nobody can direct me what I must do or say, insofar as I'm seized with the facts and the law that I have to apply to the case that is before me. So I will not entertain any direction from even the president or the chief justice. And that is the independence I'm talking about. Now, the other side of the independence, which I think that overlaps with that of the executive, is that the chief justice is the head of the judiciary and also the head of the administration. Therefore, we have to collaborate with the chief justice has to collaborate with the executive, because when we are talking about the activities of the courts, talking about remuneration of judges, also building infrastructure for the courts, office accommodation, and what have you. You can't say that because you are independent, you want to go solo. In any event, it is the executive who will give you the funds, because if you draw up your budget, it has to go to the executive. You have to go to the executive for them to give you the money, subject to the approval of Parliament. Therefore, when we talk about independence, it's not absolute, especially when we are talking about the other side of the work of the judiciary. But then when it comes to the judicial activity itself, where the judges are supposed to apply the law to the facts of the cases before them, that one is absolute. No one can interfere with the work of the judge or a magistrate. Thank you.
Any supplementary? If not, then you go to your third question.
Okay. That is okay. I have a different question. Okay, thank you. My next question is, Ghana's constitution says no numerical limit on Supreme Court justices. State the optimal number of judges for Ghana's Supreme Court and defend your answer with 3 constitutional principles. Thank you.
Thank you, Chair. Before I prefer what the demand to your answer, permit me to say that the appointment of judges, particularly to the Supreme Court, is critical and of paramount interest to the citizens of Ghana. Therefore, when you are being nominated to the Supreme Court, you must expect that you will do your work diligently and competently. Now, to the question itself, optimum number. You see, the jurisdiction of the Supreme Court is so wide in comparison with other Supreme Courts, even our next door neighbor Nigeria. The Nigerian Supreme Court exists with only 2 jurisdictions. One is appellate jurisdiction, civil and criminal. The original jurisdiction is another jurisdiction they exercise. But in that case, it's about disputes involving the federation and the states in Nigeria. For example, if the federal state runs into conflict with, maybe let me say, Kano State, and the issue have to be resolved, or the dispute has to be resolved, it is the Supreme Court that resolved that issue. Then they also have the jurisdiction, the original jurisdiction, to resolve disputes between states. So, for example, we can say that there's the dispute between Kano State or Lagos State. Apart from that, there are no cases that go to the Supreme Court. In contradistinction with our Supreme Court here, our jurisdiction is so wide. We have about 7 or 8 types of jurisdiction that the Supreme Court exercises. The first one is the appellate court, where they will look at both the civil and criminal appeals that come from the Court of Appeal. We also have the original jurisdiction, where the Supreme Court is called upon to interpret provisions of the Constitution which people think, or the parties in the case may think, that they have given varying opinions, so that if the parties have not added them as to the nature of the provision or the intent of the provision, it is the Supreme Court that they will go for the resolution of the matter for purposes of interpretation. Now, they also have the power to enforce its orders, and also to enforce human rights. Beyond that, we have the reference jurisdiction. In that case, if there's a case pending before a high court or the Court of Appeal, and it borders on interpretation of some provisions of the Supreme Court, because the Supreme Court has been given the exclusive jurisdiction to interpret the Constitution, the judge in that case will have to stay proceedings and refer the matter to the Supreme Court. And that is covered by one of the provisions which, if I'm permitted, I could refer to it. But that provision in the reference provision in the Constitution is also reenacted in the Courts Act, Section 100, which also says that when there's an issue as to interpretation of a provision of the Constitution, you will have to hold on with the trial of the case and refer the matter to the Supreme Court. So till the Supreme Court gives decision on that issue, the case in the trial court or the lower court will have to be stayed. There is also this other jurisdiction, supervisory. The supervisory decision is about the Supreme Court exercising authority over the work of Parliament to see whether a law that has been passed, or constitutional instrument or an executive instrument, was varies the powers of the Parliament. In that case, they will go under Article 2.1 and Article 130 of the Constitution, and make a determination as to whether the Parliament, didn't have that power to do what they did. Beyond that, the Supreme Court is also seized with that power of hearing appeals from the National House of Chiefs. But before the case goes to the Supreme Court of the National House of Chiefs, the appellant who is challenging the decision of the National House of Chiefs must obtain the leave of the National House of Chiefs. If it is refused, that application must be repeated at the Supreme Court, and if leave is granted, that is why the party will have the right to file its appeal. There's this other jurisdiction which the Supreme Court exercises, and that borders documents that must be, that affects the security of the state. If there's a case before a trial court, like the High Court, and there's an issue as to whether a document which must be produced is going to affect the security of the state, the matter has to be referred to the Supreme Court to make that determination. And when the Supreme Court is holding that session, they do it in camera. They also have what you call the power of prerogative of mercy. In that case, if the president is exercising his prerogative to set a convict free, and the president is not sure as to what must be done, the Constitution says that refer the matter to the Supreme Court for advice. So, Mr. Chairman, you can see that the jurisdiction of the Supreme Court is so wide that it has also created the opportunity for cases, more and more cases being filed in the Supreme Court. It may interest Mr. Chairman to note that a case that started in the lower court, maybe the district court, can even travel as far as to the Supreme Court. Of course, when the case on appeal comes to the High Court, and the person who lost is dissatisfied, he will go to the Court of Appeal. Must be recruited to deal with those cases. So if you ask me, the minimum number that I will recommend for appointment to the Supreme Court, given the nature of the work they do, they are noted with so many cases. Therefore, I think I would suggest 20 as judges that should go to the Supreme Court, because as a matter of rule of procedure, and it is also even backed by the Constitution, when the Supreme Court sits in an ordinary case, the panel is 5. The president will sit together with 4 other Supreme Court justices. If there is the chance to have the matter reviewed, 2 more justices will be added to it. So even in ordinary cases, you will see that in each case there are 5 judges who will handle the case. So if you say that judges mustn't be sent to the Supreme Court, then it means that you are giving the court more and more, they will be started with more and more cases, and they cannot handle. So at any given time, when the panel or the judges in the Supreme Court are about 20, then we are saying that we have about 4 sets of panel of judges to handle those cases. So, Mr. Chairman, I would say, in my humble opinion, given the cases that are in the Supreme Court, I would recommend that 20 judges would be appropriate. Thank you.
Thank you very much. Any supplementary question? You can ask a different question. Yes. Your limit is 3. If there is a follow-up, fine. But if it is not a follow-up, I'll give the floor to Honorable Anthony Imie.
I'm the chair of the Judicial Committee. Do you know that?
As a chairperson of the Judicial Committee, you can be given a number of questions to ask far above members' of this thing. But if you have a follow-up on the question that you ask, I will allow it. But if it is a different question, you don't have a right so to do. Yes. So the follow-up must emanate from the
follow-up question is, even with the existing numbers, people were complaining of parking judges at the Supreme Court, and you are proposing increasing the number to 20. Then that means we have to review the Constitution or educate us. Thank you.
Honorable member, the Constitution doesn't place any limit. There is no gap placed by the Constitution. Therefore, the number can be increased to 50 without revising the Constitution. In the Constitution.
Nominee.
But the question that you asked, it is clear that there is no limit placed. So, very well. So, Honorable Anthony Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my lord.
Thank you.
My lord, going through your CV last night, I took interest in particularly page 2 of your CV, your work and professional experience.
Yes.
I realize that you have risen from the ranks, from the rank of a court recorder and almost at the apex court. I would want us to do a little bit of exercise in view of your experience from the judicial service, not at the judiciary.
Okay.
My first question is, from your experience, do you think that premium is being placed on the judicial service in view of the fact that all trainings, JTI trainings, workshops, etc., majority of them are organized for members of the bench? That's my first question.
Thank you, Mr. Chair. I will venture to say that when we are talking about training or capacity building, it should not be limited to only the judges. Why? Because if the registrar doesn't know his work, the chances are that he can even mislead the judge. His son is now a justice of the High Court in Cape Coast. I can name them and name them. I'm a living testimony, as my CV will show. I had opportunity to go to school. And Mr. Chairman, permit me to say that it's very essential that an employer must always try to encourage the staff, and in this case, not, as I said, not only the judges, but also the auxiliary staff and the registrars. I had the privilege of working with judges. I was in Sekeni High Court when I had the opportunity to go to school. I worked with a judge called Ansechu. I owe Ansechu a great of gratitude. May his soul rest in perfect faith peace. I was my judge, so I was the crack to him. I was very, very committed to my work, and the man took interest in me. I may say that Justice Ansechum, and I applied myself to what he said. So I had the opportunity to go to the university in 1988 to read Diploma in Public Administration. I went back to Sekeni, and then the following year, I had the chance to then go to the law faculty to read law. Went to Makwala to do my professional course, came out, and then went back to the service. Started as a magistrate, and I haven't looked back. So, and I must say, with all due respect, that my work has always spoken for me, and the records are there. It was because...
So, my lord, we don't intend to keep you here for long, so be brief.
So, what I'm saying is that I will say that when we want Ghana judicial service to grow in leaps and bounds, we need to, one, build the capacity of the judges. There's this myth that the law is in the bosom of the judge. But if you, the judge, you do not educate yourself, how would the lawyer come and say that the law is in your bosom? So you need to educate yourself. Two, the infrastructure of the service, when you go to the hinterlands, they are so in some... I started from Sehi also. We were, you know, so we need, and with your approval, please, when our budget comes here, I'm pleading, don't cut our budget, approve for us, so that the Chief Justice will use that to, you know, acquire more, build more courthouses, renewed office accommodation, resident for the judges, because when you work in a serene environment, that even gives you the edge to work hard. I also think that there must be some reforms even with our laws. The law that we are using, they must be overhauled. For example, the Act 30 was passed in 1960, and there's the need. Now we are in 2025. Some of the provisions have achieved its usefulness, so we need to, you know, amend some of them so that there will be speedy recovery, speedy trial of cases, and so forth and so on. So my experience has shown that I will give premium to capacity building, and not only judges, but also the staff, and particularly the registrars. Thank you, Mr.
Any follow-up?
Thank you very much. Yes, I have a follow-up. So you would agree with me, my lord, that there hasn't been proper, for instance, orientations, proper trainings, proper in-service training for persons like registrars. You agree with me?
To some extent, I will. But to a larger extent, I will also be. And what it does is that it organizes courses periodically for judges and the registrars. I have even trained some registrars of the Court of Appeal and court clerks. So, and in recent past, some registrars were sent to the UK to undergo some studies. They said rapes or raper, I've forgotten exactly what it is, but all in an effort to build the capacity of the register. So it's not only the judges that these courses are offered to them, but also to the registers as well. But of course, the JTR, that is the Judicial Training Institute, must be resourced so that they can organize more and more courses for the registers. Thank you.
Thank you very much. Any further question?
Yes, my lord, can you tell this committee, how often does the JTI organize capacity building workshops, for instance, for registrars? Let's limit it to the High Court.
Well, I will take that to be a fresh question. So, question number 2.
I know for a fact that they do organize this. They do organize courses for the registrars, but how often I cannot tell. Thank you.
Is it the case that when registrars are appointed, no form of orientation is given to them before they assume office?
To a very large extent, I would say yes. Thank you.
I don't remember your last question.
A follow-up to this one. That was the second question. So I have a follow-up.
You want me to treat it as your third question?
No,
so that you ask a follow-up
to
on
the
this?
second question. The last one was the second question.
Yes.
Yes, so I have a follow-up to the last question.
That is the training for... Very well.
Yes, now, my lord, would you advocate that the budget for the judiciary is prepared in such a way that enough funds would be set aside for the training of both the judiciary and staff of the judicial service? Would you advocate that?
Thank you. In fact, that system is already in place. Parliament has given the judiciary part of the revenue that we generate to oversee our running cost and the rest of it. But you see, it's not enough. So, like Oliver Twist, we are saying that more and more resources must be given to the judiciary so that we can work efficiently and effectively. Thank you.
Thank you, my lord. Now, from the internally generated funds of the judiciary, 30% is retained, while 70% goes to the government. In view of the fact that the judiciary is always struggling to meet its demands, would you advocate the uncapping of the funds so that the entire 100% of funds generated would be left for the judiciary to do business with?
Subject to the fact that that is not capping, you may proceed to answer the question.
Mr. Chair, can you repeat the question for me?
Very well, my lord. My lord, what I mean is, funds generated from the judiciary keeps just 30% of the said amount for its use. The 70% goes away to the government. What I want to find out from you is, in view of the fact that the judiciary is struggling to do its work, do you think that it would be appropriate for some law being passed, some permission being granted for the judiciary to retain everything it generates for its use?
Indeed, it would be a good idea if that was done, but I'm afraid the revenue that we generate is also backed by law. It must go to the consolidated fund, because it is from the consolidated fund that the government, applies to its activities, including institutions of state and the judiciary. So, to say that the judiciary should retain 100%, I will not advocate for that, but I will say that maybe about 50 or 70% must come to the judiciary. Thank you.
I'm very grateful.
Thank you very much. I will then give the floor to Honorable Bede Awantanzuma Azidi.
Thank you very much, Honorable Chairman. Congratulations, my Lord.
Thank you.
Yes, my Lord, I've gone through your CV, and I've also listened to you. Honestly, there is absolutely no reason why you should not be appointed a Supreme Court judge.
Thank you.
You have done all that it takes to become a judge, right from the magistrate through the ranks at the Supreme Court. And I think that I will not worry myself about whether you are qualified to be a Supreme Court judge or not. You are. And so I have no questions for you, my Lord.
Thank
as far
you.
as I'm concerned, you are fit for the job and you are fit for purpose. Thank you.
Thank you.
Congratulations.
Thank you very much. It's now the turn of Honorable Tampuli. You have the floor.
Thank you very much. My Lord, good morning and welcome.
Thank you. Good morning.
And congratulations, my Lord.
Thank
My
you.
Lord, I heard you talk about the jurisdiction and the workload of courts in Nigeria, Federal Republic of Nigeria. And I want us to do a bit of comparison with ours here.
Okay.
So the Nigerian Constitution 1999 as amended, and in their case they call it sections. Section 2302B of the Nigerian Constitution provides, and I quote, "The Supreme Court of Nigeria shall consist of such number of justices of the Supreme Court not exceeding 21, as may be prescribed by an act of the National Assembly." In Ghana, ours is in Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. End quote. So, in other words, they have a ceiling, but we have a floor. So, at some point during the presidency of President Buhari, they even had 13 justices of the Supreme Court, the Federal Republic of Nigeria. But is this sustainable? And having regard to the fact that Article 128 is not an entrenched provision. The entire Chapter 11 has Article 125, 127, 145, and 146 as the only entrenched provisions. Do you think we should do something about this, especially having regard to the fact also that 230 million people reside in Nigeria and about 32 million in Ghana? We have not less than less than 9. They have not more than 21. Don't you think by reason of these numbers, ours is a bit on the high side and potentially can even go way higher?
Thank you. Thank you, Mr. Chairman. I will start off by saying that if there should be need for expansion or capping of the Supreme Court, I think that there must be a wide and expansive consultation among all the stakeholders, lawyers, GBA, constitutional lawyers, the academia, even the political parties themselves, so that we will all come to consensus as to what we must do. And if there's a consensus that there should be a cap, then the law has to be amended. Fortunately, as you said, I also looked at the law, and that is not an entrenched provision of the Constitution. So the amendment, as it were, can be done without much difficulty, except that, as I advocated, there must be a very wide consultation. I brought this report, an annual report of the Judicial Service, and as at June 2023, this report was issued to us last week. 595 cases were pending in the Supreme Court. So when we are talking about capping, we must also take into consideration, as I've said already, the number of cases that are in the Supreme Court pending for attention. Thank you.
Chair.
Any follow-up?
Follow-up question.
The ground rules.
In view, I acknowledge, the ground rules. In view of the expansive jurisdiction of the Supreme Court, chieftaincy, jurisdiction, election, Supreme Court, presidential elections, and so on and so forth. Now, don't you think that there is need for us to stop the jurisdiction somewhere of the jurisdiction of the Supreme Court, especially, you can take, for instance, interlocutory appeals. Rules of Court Committee can, by CI, come up with something. Can you propose some limitation to the jurisdiction of the Supreme Court? Which jurisdiction do you think should be set aside and at the Court of Appeals? And then which one should continue to remain with the courts? And by the way, at some point, the Supreme Court of Nigeria had over 10,000, pending cases. At some point in 2022, over 10,000 pending cases. I thank you, Mr. Chairman.
Thank you, Mr. Chairman. You see, I will say that first and foremost, the Court of Appeal must be very strong. I mean, being strong means that we need judges who, they are doing their work very well, I must admit. But we must make it stronger than now, so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the Rules of Court Committee to ensure that, and of course we can't do that without, we have to subject the debate very wide so as to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away. For example, if I should be given the opportunity to say, to recommend, the prerogative of mercy that is exercised by the president, I think that should remain with the executive. It shouldn't come to the Supreme Court. Because after all, the Supreme Court itself has pronounced that when it comes to matters of advice, the president may take it or may not. Thank you.
My Lord, with the leave of the chairman.
Please, he said the mercy, not writ.
Prerogative of mercy.
Mercy, yes, prerogative of mercy, which is vested in the president. The president may come to the Supreme Court for advice. And once the interpretation placed on the advice is not compulsory or is not binding on the president, he feels that it should rest with the president. Yes, 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 yes. Honorable Bafoewa, you have the floor.
Congratulations, my lord.
Thank you, Chair.
My lord, I was happy to hear you say that there's the need to build a strong court of appeal, so that a lot of the cases that travel as far as to the Supreme Court will be reduced. My lord, when you take the law reports of the Republic of Ghana, there's one observation you are likely to make. A significant number of the cases determined by the Supreme Court, by the Court of Appeal, are overturned by the Supreme Court. In recent history, if you even look at the number of judges being appointed from the Court of Appeal to the Supreme Court, it's indicative of how strong our Court of Appeal is presently. But this is the situation. Why are we having that experience? Because currently we say we have a strong Court of Appeal, yet a significant number of cases are being overturned by the Supreme Court.
Thank you, Mr. Chair. In fact, I haven't had the benefit of that research you are talking about. So let me file a caveat. I will not be able to answer directly why that is the case. If I've had benefit of it, maybe I can profess an idea as to why that is the case. Thank you.
Thank you very much. Honorable Alik Blim Akurugu.
Thank you, Mr. Chair. Congratulations, my lord.
Thank you.
Yes, there has been growing concerns about expanding access by breaking the monopoly of the Ghana School of Law. There are a lot of people who have completed their LLB and are home. Some of us are even planning to go read law, but we get scared about what is happening. What do you make of it, or what can you advise for our students who have been home for many years and haven't been called to the bar? Thank you.
Thank you, Mr. Chair. The number of students that are trying to get to the law school has increased significantly, because now we have universities that are offering LLB courses. In our time, it was only the University of Ghana, and then from there you come to the law school, so the number was few. Now it has been expanded without corresponding maybe infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe, depending upon how the General Legal Council are going to do it. I think they can put a system in place where the students can be, grouped, and then they are given the chance to do the courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school. Because invariably, everybody who has entered the law faculty to do LLB who wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Council, together with maybe the director of the School of Law, they need to sit down and fashion out. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is another way of maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Council, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Council must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance your social life with your career? Thank you.
Thank you. The life of a judge is something which, unless you have come into a fold, you will, because the steps that you take, wherever you go, and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it gives room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last nominee said something which we were all amazed, that because of his work, his marriage has to suffer. That is the kind of reality. So, and the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him because people will say that he is the friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Yaoboma.
Thank you very much. Congratulations, my lord.
Thank you.
Chairman, full disclosure, my lord has been a very good friend of mine for many years. And I'm happy to see you go up as a Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to send up there. And I wish you well.
Thank you.
My lord, First time I appeared before you was about 14 years ago.
Oh, is that so?
I remember Republic versus Oseje, Antonia Kuto say Jambafo, was for Professor Jambafo. And the former Attorney General was for Oseje. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Oseje got out of the woods. I've read recently some decisions of yours, the Amewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Bafo to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Oseje, Jambafo, Atufosi and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu?
Amewu. John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for hearing. The appeal itself is pending for hearing. So it will be unethical for me to say something about it. Thank you. In the case of Oseje,
hello, do you still remember the facts? Talk about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go up. So it will be very difficult on my part to discuss it now. Unless, so please, let's.
Ballard, I'll step it down and,
thank you.
And ask you if you still have some good friends at the bar, because when you are at the financial court one, anytime a case is brought to you and the lawyers discuss, they say, you are going to Justice Bright Mensah's court. Oh, no, it's real. Even if he's dismissing your application, he won't even put a smile on his face. He will just ask you to go out. My Lord, all I want to entreat you and beg of you is to keep being yourself.
Thank you.
Keep being a firm judge.
Thank you.
And I wish you the very best. Thank you.
But you see, Chairman, please, my court is a very friendly court. Very, very friendly. If sometimes, thank you for the comments.
Yes, I'll give the floor to Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my brother.
Thank you.
Looking at your CV and where you are coming from, you deserve it. You've worked so hard, rising through those ranks.
Thank you.
I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level. But here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about facts that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga, you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals, so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower court, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the bulk of the court. Indeed, when we are talking about access to justice and quality justice for that matter, it starts from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also saddled with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the conditions of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.